Yeah. Mm-hmm.
So we just want you and Chris.
And it's recording right now?
Yeah, because it records.
As soon as you start?
Yeah, so.
Will we be able to edit this out?
Yeah. Yeah, definitely.
Okay. You know, I don't want to be on, how do I want to get rid of video. Stop video. There. Phew, I'm happier.
Is anything coming up on, you can't see me, right?
No.
Yeah, right now it's just your voice.
So I'm going to head to the bedroom, I guess, so we don't have this feedback. Okay, so I'm going to do this in the bedroom again, so we don't have feedback, and then he'll just upload slides.
Mm-hmm.
What? We said 12. Oh, I guess I don't need to yell because you can hear me. It says we already have 14 participants.
Yeah.
Fuck, really?
So once
They didn't see me walking.
So once Chris signs in, then all he has to do is hit share. And upload the, or I can also upload it as well if he needs me to do it.
You know, it's funny. I'm not on mute.
Hello, this is Chris.
Hi, Chris. How are you?
I'm doing great. How are you guys?
Well, thanks. Hey, so you should have an option there to be able to share your slides. Or
I see share screen. Would that be it?
Yeah, you just you press the share button. It should be a green share button on the bottom middle portion of the screen, and then you hit share, and it's going to give you a couple options. And one is that you can upload like any PowerPoint or document that you have already saved onto your computer. So you can upload the PowerPoint that way, and you can flip through it that way.
Cool. Okay.
Your audio will be done over the PowerPoint.
Okay. So I'm just trying to figure out where it's giving me some weird options when I click share. It doesn't ever give me my files, and on my laptop, it's giving me some others.
so it should show your screen, or we can do it on our end and you can just say advance slide and then I can do that.
Well, I mean, I would strongly prefer to do it on my end, only because it
Sure.
will flow a little better.
Mm-hmm.
Give me a
Should be
sec.
able to do it.
I don't even have it pulled up yet, so let me do that.
You do have 21 participants on thus far.
Awesome.
Hello, everyone.
Can you see that? Hello?
Yeah,
Yes,
we can see it.
we can see it. So we see, it's not in the full screen view.
It's about to be. Give me a sec.
Okay, yep,
Right there.
yes.
Okay.
And then people, let's see, on chat. So Deborah says we're getting a lot of feedback from Chris.
Still, all I have is a laptop with a microphone, so I don't have any other devices on in the office that would cause that, as far as I know.
So Deborah Ferguson, if you can hear this, are you still getting that feedback?
It should be also for the main. So yeah, we can go. We're
Chris,
ready.
we're hearing the audio is good now.
Okay.
And I did say that we'll send out the slides to all the attendees.
Totally fine.
Great. Hello, everyone. This is Colleen McAleer. I hope you all can hear me well. I wanted to first thank everybody for joining us today, and especially thank Chris Riffle and First Federal for being willing to provide some expertise in this regard during this period where everyone's got a lot of concerns and we all are looking for answers. And as we sit and wait, I know that it creates a lot of anxiety. So really appreciative of our partners that they're able to put forward their expertise as they start to analyze all of the information so that it can be shared to everyone in the community broadly. So I want to make sure everybody knows that this will be recorded, is being recorded, and that we will provide the slides to anyone that has signed up. We've got your list in your email. So Peggy Simmons, it will come from her email address. We'll send out a copy of the slides to everyone. And also, I wanted to make sure people knew that they should be looking out for an email from us later today. We will host another webinar on Friday. Susie Levine and the number 2 person at Employment Security Department will be hosting a webinar for people in Clallam County. Susie Levine is the commissioner of the Employment Security Department, and we'll be reviewing the shared work program and partial unemployment, and there are different programs that they have for employers as they're reviewing what steps they're going to be taking with their employees. So be on the lookout for that webinar, or an invitation for that webinar, I should say. And lastly, I want to just give a quick update. You know, there are all sorts of requirements from the Families First Coronavirus Response Act that Chris is going to be going over with you today. And as we know, for most business owners right now, cash preservation is king. And that's what people are really focused on, trying to bridge this period until we're able to do business again. And so with that, this act does put on new requirements for business owners where they aren't able to preserve their cash. However, that being said, right now, as the federal government, Congress is discussing the CARES Act, which is that $2.5 trillion bill you've been hearing about on the news. There is a portion of that which applies to small businesses. And that portion has not changed lately. And if it passes as is, there will be a substantial amount of funds available for businesses in Clallam County, meaning that it's 350 billion is the last version that was sent to me from Congressman Kilmer's staff today. And again, this has not yet passed, but the 2 programs are the 7A, an SBA loan, 7A Paycheck Protection Program, which is new, which basically if you keep your employees on board, if you rehire them, or if you keep them on board through June 30th, that they will give you a loan that then if you show that you've kept them on payroll during the covered period, then you do not have to pay that amount back, and that you are not required to make any payments on the loan until the end of the year. There's a lot of stipulations, but it does apply to nonprofits. It also applies to independent contractors and small business owners. And then there's also the economic injury disaster loan, which is a lower interest rate loan, and it too does not require any payments, but it's for a lower amount. And there's an amount of $10,000 that a entity would receive within 3 days of SBA receiving the application. So that being said, I'm going to kick it off to Chris now, and just thank you for joining us, and be on the lookout for the next email on the webinar for Friday. Thank you. Go ahead, Chris.
Thank you, Colleen. Hello, everybody. My name is Chris Riffle. I'm the General Counsel and Chief Operating Officer here at First Federal. Prior to coming over to First Federal, have had a long-term private practice here in Port Angeles, and then Omaha before Port Angeles, where I spent some time working with probably a lot of you to some degree. I don't know who all is on the call, but working a lot in employment law generally. And Colleen contacted me on Saturday, wondering if I knew anybody, any attorneys locally who would be able to and willing to present on this act that I'll get into in a minute, with kind of a wink wink, which was Colleen's way of saying, Chris, would you do this? And I am very happy to do what I can to hopefully create some clarity and understanding to what is a very fluid and unprecedentedly fast moving process and environment that we of course have never seen before, with the act that we're going to talk about today, plus the CARES Act that Colleen was referencing that hasn't been passed yet, but looks to have a significant amount of bipartisan support, and is probably going to pass, and that's going to create also a lot of confusion about where that money is going to be going, how do you get your hands on it, and what are some limitations. And I think, unfortunately, we're having to react to these things in such a fast pace that the legislation is being passed before the answers to most of our questions are being answered. And so I suppose, for what it's worth, this is going to require a little bit of patience as we start to better understand the inner workings and mechanics of both of these acts. But Colleen specifically asked me to present on this act, which was passed, I think it was last Wednesday, the 18th, called the Families First Coronavirus Response Act. And this is phase 2 of what will be at least a phase 3 or 4 response by the federal government to the current crisis. And this is information about me. I should add here, I put my email address on here because I'm perfectly willing and happy to answer or try to answer any questions that you have offline. If you're interested, feel free to email me, and I'll either get you resourced or try to answer your question as best I can when it relates to this act, or if there's anything else you need. Certainly feel free to see First Federal and me as a resource to the extent you need it. And then, of course, as an attorney, I have to issue my disclaimer, which is, this is not legal advice, and it's meant for general informational and educational purposes only. So don't take it as legal advice. Okay. Oh, and lastly, I guess as a point of order, it's very likely that you'll have questions during the presentation or about something in the presentation. I'm not a big user of Zoom, and so I don't really know how this works generally, but I would like it if we could either do those by chat, and maybe Colleen can keep her eye on that for me, or save those questions for a Q&A that we'll have at the end, where we'll certainly be able to talk more about this stuff or any other questions you have.
So, Chris, there is the Q&A piece at the bottom of everyone's screen. And so you can put a question in there, and we can just kind of take those on the fly, or wait till then and see if the question applies to what you're going over right then, and then maybe I'll jump in. I will have to get off at 1:59 though. So after that, I'll ask you to take it from there, if that's all right.
Yep. And I've got that question and answer box open on another screen in my office, and so I'll try to keep an eye on that as well. Okay. Okay, so the Families First Coronavirus Response Act. Here is a slide that just presents an overview of when it was passed or enacted a week ago. Very broad bipartisan support. And importantly, its effective date at this time, at least, is April 2nd. which is 15 days after the president signs it into law. And also very important for the things we're going to be discussing here is that this expires on December 31st. So there is no carryover into 2021, at least at the present time. In the green box below, I just kind of bullet point the various big picture tenets of the act. It creates funding for domestic nutrition programs for schools and others, or children and others. Broad mandate regarding providing funding for testing publicly and to different demographic groups, and a specific requirement that a private insurance provide coverage for COVID-19 testing. Funding for states for activities related to unemployment benefits. This is an acknowledgement that there's going to be a massive influx of claims, and it's funding to allow for additional support, not funding for the claims, but support for the offices that process the claims. And then the last three bullets are where we'll spend most of our time. This is an amendment to the Family Medical Leave Act called the Emergency Family and Medical Leave Act, or what you'll see throughout this as EFMLA. And also an amendment and expansion of paid sick leave requirements at the federal level with the passage of the Emergency Paid Sick Leave Act, or what we will see as EPSL. And then lastly, the establishment of tax credits for money that has to be spent under the EFMLA or EPSL. The way these are organized, if you look at the upper left corner in a green box, this is the topic specifically that the slide relates to. And we're going to start with the EFMLA. The overview here. I'm going to assume that most of us are familiar with what the Family Medical Leave Act is, and I'm not going to really get into the specifics of that act or what companies are or are not subject to that act, because for purposes of our conversation, it doesn't matter, because this Emergency Family Medical Leave Act applies to all companies. You'll see the third bullet here applies to all employers with fewer than 500 employees, and that's all of them. And we'll talk about a possible carve out later. But it's a paid leave. It's specifically paid for caregivers of children with closed schools. So it's the parents and other caregivers and guardians of closed schools. As I indicated, it applies to employers with fewer than 500 people, and it applies to employees who have been employed for at least 30 days. So there's a 30 calendar day requirement of employment for them to get benefits under this specific act. The EFMLA requires paid leave after 2 weeks. So there is a 2-week period of non-payment under this act at least, but you'll see that later that the Emergency Paid Sick Leave Act covers those 2 weeks. And so there's kind of a synthesis between the two. We've got a cap on benefits at $200 a day per employee, or $10,000 total per employee over the course of the coverage. The employer must pay employees at least 2/3 of their usual pay. Of course, employers are free to pay more, but there's no tax credits for anything over what the act covers. And then this last bullet on the page, I specifically reference variable scheduled employees because not everybody's a full-time or has a specific number of hours each week. And you'll see what the act says is you should use the average number of hours scheduled per day for the previous 6 months if the employee has worked that long. But if not, then you use the hours the employee reasonably expected to work when hired as the calculation of pay.
So Chris, there's a good question from Melissa Williams. She says, how does this apply to tax exempt organizations if the benefit to employers is delivered as a tax credit? Are there special provisions for nonprofits?
I have not seen any special provisions for nonprofits, and however and so I don't believe the act is that specific, but the act also authorizes implementing regulation, and so a couple of other bodies in the federal government are charged with the implementation regulation, and it's very possible that there will be some specific language or carve out to cover that circumstance. But as you will know in this conversation, but also with respect to the CARES Act. And as I've alluded to earlier, there's going to be a lot of questions that we can't answer yet because this is all happening so fast, and there's going to be a catch-up process that happens with regulation. There's a tax credit for payment under the EFMLA. Private sector employees will receive 100% tax credit for paid leave under the up to the caps. The tax credit applies against employers' payroll tax for that calendar quarter. Interestingly, if the amount you've paid under the EFMLA exceeds your payroll tax liability, you get a credit paid forward. So there's an added benefit that you're not capped even by your own employer payroll tax liability. And then, of course, public sector employers don't receive this tax credit. And then the tip I have here, and this is going to be really important because of the fluidity of the situation, is to be able to keep very clear and concise records showing when paid leave was provided under the EFMLA, and then also the Paid Sick Leave Act versus any other instance where paid leave was offered or paid. Okay, so qualifying events, these are what qualifies you for the EFMLA coverage. The employee must be unable to work, specifically including physical work, or what the Act calls telework, which is an interesting term to me, but just means working from home, and unable to work due to a need for leave to care for a minor child of the employee. And this is very clearly targeted to the schools and other educating institutions that are closed by public mandate under a public health emergency. And you'll see that term underlined in the last sentence here, and it's defined down below. The COVID-19 response certainly qualifies as a public health emergency. And then the term child care provider is also defined. It's a pretty broad statement, but it's a provider who receives compensation for providing child care services on a regular basis. So it'd be schools, even though they're not technically providing child care services, but and I mean certain parts of schools, but also child care that's provided either after school or for children who are not yet in school. And then covered employers, and this is the part that is pretty sweeping and interesting, that it covers all private sector employees with fewer than 500 employees and all public sector employees. And so I kind of get into just a brief analysis of the distinction between the EFMLA and the FMLA. In the next bullet, the means for provision may apply to some employers exempt from the FMLA. So if many employers are too small to be subject to the FMLA, and some of the hour requirements and size locations are listed there. But the EFMLA, try that again, EFMLA applies to all employers under 500. And down at the bottom, the Act also lists a possible exemption. It empowers the Department of Labor to exempt an employer with fewer than 50 employees if it's determined that compliance would jeopardize the viability of the company or the employer altogether. But as I've indicated, there's no specific statement as to whether the Department of Labor is going to do that and what specific standards it would use to measure the exemption or not. It's still working on the implementing regulations. And then eligible employees, as I indicated earlier, we're talking about those who've been working 30 calendar days or more. The first 10 days of the emergency are unpaid under the EFMLA, although employees can elect to use other paid benefits to the extent they have them, accrued vacation, PTO, et cetera. This last bullet I won't get into too much, but there's a specific carve out for employers of healthcare or emergency responder employees because of the public interest in having those folks at work, that they're excluded from eligibility for the EFMLA. So a few other components of the EFMLA, the length of time the benefits must be provided. This is similar to the FMLA. It's a 12-week of coverage program. So there has to be at least 12 weeks of coverage under the EFMLA to the extent the employee qualifies for that coverage. And then job restoration. This is a big part of the FMLA, of course, is the requirement that the employer from which the employee was using FMLA benefits or leave preserve that person's job or an equivalent position for that person as they come back to work. The EFMLA requires the same thing. There are special rules for employers with fewer than 25 employees, and those provisions are listed right below that green box on the lower part of the slide. That there is not a requirement to restore that employee if the employee's position no longer exists because of the economic conditions or changes because of the public health emergency. The employer makes reasonable effort to restore the employee to an equivalent position. So if there's an attempt to do that. And the last one is if the restoration isn't reasonably possible, that for a year, the employer makes some reasonable effort to contact the employee if an equivalent position becomes available. A few other components, the notice of leave, the employee is required to give the employer notice of the intent to use EFMLA coverage. What's not clear under the EFMLA is that there's a requirement that the employer provide notice of this coverage. It would probably be a best practice to provide that notice and hang it where appropriate. This is different than the EPSL, where there is a requirement to provide notice of the coverage. And then enforcement, the Department of Labor is permitted to pursue penalties similar as it would under the FMLA. And there is a private right of action or subject to employers of 50 employees or more, where employees could bring a claim if there wasn't proper coverage provided. So I suppose, I know I said earlier I would do the full presentation and then move on, but that's the end of the EFMLA part of the presentation. There are 3 examples that I will have for you at the end of these slides that kind of paint a more real-world picture of the deployment of both of these. But are there any questions specific to this act at this time? Okay. Well, if there are, please, oh, I see one now from Jeff Cox. Does the EFMLA cover shelter-in-place order without children? And the answer, it flatly is no. It's very only specific to the instance of kids with school closure and the need to leave work to care for those kids. Doesn't mean there's not coverage otherwise. It just doesn't cover under the EFMLA. Well, we're about to talk about the paid sick leave, and you may find a better answer here. The EPSL provides paid sick leave to all employees, full and part-time, of covered employers, and this is going to be all employers under 500, regardless of the employee's duration of employment, who are unable to work or telework because of the need to take emergency sick leave. And that concept of emergency sick leave is very broad here, you'll see. The EPSL require, so there's a lot of information on this slide, and I saw a question about emailing the slides at the end, and yes, those everybody who's an attendee at this will get a copy of this. And again, I'm perfectly happy to answer questions the best I can if you have some afterwards as well. The EPSL requires private employers with fewer than 500 employees, same standard as the EFMLA, and all public employers, to provide an additional 80 hours of emergency paid sick leave to full-time employees who are unable to work or telework for specified reasons related to the coronavirus. And there's going to be more on this in another slide here, but just the basics are employees who are subject to a federal, state, or local quarantine or isolation order. That would be the shelter at home order, advised by a healthcare provider to self-quarantine due to COVID-19 or experience some symptoms and are seeking medical diagnosis but haven't yet reached that diagnosis. If any of these 3 instances apply, then the employer is required to pay emergency sick leave wages because at the full rate of pay, and that's important. So 100% of the rate of pay for up to 80 hours. And then there's caps on this. The wage payment is capped at $5.11 per day or $51.11 in the aggregate per full-time employee. So you can see that this is a pretty sweeping and invasive requirement to pay emergency sick leave to employees for various instances, and these are just 3 of the instances. There's more coming up. But with these 3, important note is that, as I said earlier, it's the regular rate of pay that must be paid to the employee. Those same full-time employees are entitled to 80 hours of paid sick leave at 2/3 of their rate of pay for these instances here. And these are to care for an individual, and I put that term in quotes, for the reasons stated on the previous slide. So those first 3 things here, these 3, the subject to the quarantine or isolation order or having health conditions, So if you are needing time off to care for people that are in that circumstance, then you're entitled to 2/3 of your rate of pay for 80 hours. And the important note there, and this is very broad, is that this isn't limited to family members like a FMLA is limited to family members. This is any individual, and you'll see an example later where I play out that scenario. Also, another reason would be to care for your child if the child's school or place of care is closed, or the child care provider is unable to provide care due to a public health emergency. And this is the point that I was making earlier with the EFMLA, is even though there is a non-requirement to pay for the first 2 weeks under the EFMLA for childcare, the EPSL covers those 2 weeks because the coverage under the EPSL here is 2/3 of the rate of pay immediately up to 80 hours. So for those 2 weeks. And so there is not, in fact, as it looked like under the EFMLA, a 2-week waiting period because the EPSL comes in and covers that 2-week period. And then after that 2 weeks, the employer can provide or would be required to provide the care or the coverage, so the benefits or pay under the EFMLA. And then the last one is ill-defined, but it's the catch-all if the employee is experiencing any other substantially similar condition specified by the Secretary of Health and Human Services. And this is what part of the regulatory piece that hasn't been written yet, but this is probably going to be a pretty broad provision that covers all sorts of scenarios where folks have, perhaps some respiratory illness or pre-existing conditions at work and can't safely or feel safe at work. My guess is there's going to be coverage under this provision for something like that. And then you can see the caps as well, $200 a day and $2,000 in the aggregate per employee. I'm looking at questions here. Priscilla Schaefer asked a really good question that I address a little later, but I'll address it now. For the additional 80 hours of sick leave, do employees have to use already accrued sick and vacation time first? And the answer is no. Not only is it no, they do not have to. This is in addition to, but an employer can't require that they use other accrued sick time and vacation time first. This is coverage first coverage. And so it has to be offered in conjunction with and collaterally with any other coverage. So an example on the slide here where there is coverage for 2/3 pay, if an employee had coverage that would entitle them to full pay for a period of time, then they could choose to use that first, but they're not required to use it first. And then Kathy asks, will the EPSL pay to employees who can still work but want to distance themselves from groups, so self-quarantines? And right now the answer is no, it doesn't cover that, but this is that catch-all, this last bullet that references the Secretary of Health and Human Services. I suspect, and this is my own speculation, but that there will be something built into that that allows reasonable self-quarantine because of pre-existing conditions or other health concerns that aren't coronavirus symptoms, but are precautionary measures taken because of the susceptibility to maybe a more adverse reaction to the coronavirus. Okay, so the coverage is also for part-time employees, not just full-time employees. So we've got coverage for part-time employees to take sick leave up to the number of hours that employee works on average over a 2-week period. They're paid at the employee's regular rate of pay for the same reasons that a full-time employee would be compensated at their regular rate of pay. So that's these 3 things here, the symptomatic conditions here. And then they're paid at 2/3 the employee's regular rate of pay for the same reasons that a full-time employee would be. And that's these reasons here, where you're caring for an individual, you've got school concerns with your children. And then there's I called out specifically the part-time employees with irregular schedules, because this is a reality for an awful lot of employees, that the employee must be paid based on the average number of weekly hours they work within the last 6 months. And then if they haven't worked there for 6 months, then you'll see, I used this language similarly earlier, then must be paid based on the employee's reasonable expectation at hiring of the average number of weekly hours the employee would normally be scheduled to work. And so not necessarily how they've been paid, but they're it's just from the employee's perspective of the reasonable anticipation or expectation of hours that were discussed at hiring. And then the same caps apply as they would to the full-time employees. few other components. The effective date is April 2nd, as with the EFMLA. The tax credit, just like the EFMLA, the payments under the EPSL receive a full tax credit against payroll, Social Security taxes for qualifying EPSL payments. The EPSL will be available for immediate use to all employees regardless of tenure. There's no carryover and no cash out. These are important protections, I guess, if you want to call them that, for employers, that unused EPSL coverage doesn't carry over to 2021 under this act, and there's no cash out requirement if there's a separation of employment before the end of the year, and this is perceived as an accrued benefit. It's not required to be paid out as other sick leave or PTO might be. Okay, so then this addresses the other paid leave available. As I noted in answer to the question, the EPSL is in addition to and doesn't diminish other paid leave available to employees because of a contract, employer policies, or other federal, state, or local laws. You must track this leave separately and permit employees to use all available leaves. And again, these are collateral, not sequential. So there's not one that is preferred or required over the other, and the employer cannot require employees use other available leave first. Very important provision and prohibition that this is coverage and that can be primary if the employee chooses to use it that way. And the last is the employer can't require the employee to find a replacement to cover the hours that they won't be there. Okay, a few more pieces here, and then I've got a couple of examples, and then we can get to any other additional questions that there might be. The employee notice. After the employee first uses the EPSL, the employer may require the employee to follow reasonable notice procedures to continue benefits. So checking in from time to time, other reasonable requirements that would allow the employer to have some reasonable anticipation of leave, or how long the employee, or how many of the 80 hours the employee would be using. The Department of Labor is preparing a model notice. I believe that that's out already, and I haven't gone back to look for that, but I believe that that has been published, which employees must post, or employers, I think it's a typo on my part, which employers must post within 7 days of enactment, where other employee notices are posted. So on that place in the break room, or wherever you post notices that are required to be posted, the EPSL notice is required to be posted as well. Guidance that's out there is recommending that you provide notice to all employees by email or other communication as well, just to make sure that employees are aware of it in this time. When does coverage end? After the exhaustion of 80 hours, or with the employee's next scheduled work shift following the termination of the need for the coverage. So whenever they come back to work, or after 80 hours. And this is an important note that the Act gets into detail on a little bit, is that an employee may use EPSL coverage incrementally. So they could use it for 3 days, come back to work, and then leave again if the need requires, if they qualify under one of the qualifiers under the Act. And then, as I alluded to with the EFMLA, failure to comply would subject the employer under the EPSL to some pretty significant damages should that issue be pushed, including double damages, which isn't an area that I would suggest any employer wants to get themselves into. So even though this is a very invasive and sweeping and potentially for employers significantly problematic, not complying isn't an option, I would say, at this time. I think the next 3 slides here should be pretty helpful to those who are interested in using these slides or looking at them. What I did is put together a kind of a summary of both the EFMLA here and the EPSL here on the right, and then just sort of compare them categorically. So it's basically a summary of all of what I just went over on 3 pages. And so that should prove pretty useful, hopefully, for you. Okay, so then there's what I did is I put together 3 what I think could be real life examples of how these things would work or could potentially work, and kind of draw out the scenario and kind of how to think about it. The first one relates to an employee that her doctor believes has COVID-19 and recommends that she stay home for 3 weeks. She isn't going to be tested because she's not in a high-risk category. The question, of course, is, do I have to pay this employee until she returns to work? And as an attorney, you're not going to get a lot of yes and no answers out of attorneys. This is a probably, because there's slight equivocal answer here, but most likely you would have to pay this person. The first question to ask, though, is can this person telework? Assuming the need begins after April 2nd, again, this doesn't go into effect until then, the first consideration is whether they can work from home even if they have symptoms. And this is because this virus affects people so differently. Even though you are coronavirus positive, it doesn't mean you're symptomatic. There's an awful lot of asymptomatic people who've contracted this virus. And if that's true and they can work from home, then that's what they need to do. And there would be no coverage under either of these acts. And I kind of explained that right below there on the bullet points here. And this last one is pretty important, that it's important that this deference be made to the employee in this condition, that you not require them to telework, that there need to be a fair and reasonable inquiry as to whether they can do so. And if they cannot, then don't push it, because that can create some problems for a variety of reasons. Second bullet here is assuming they cannot telework. Under the EPSL, she's entitled to be paid 80 hours of sick time at regular pay up to $511 a day, or 5110 total. It might be 5110 total. And this is just a basic application of one of those first three pay requirements under the EPSL. And the employee can elect to use other coverage if they want to, but I underline here isn't required to do so. You want to keep careful track of what you're paying under the EPSL. And once the EPSL is exhausted, the employer should consider other paid leave opportunities, but reminding you that there's no tax benefit or tax credit for any other coverages provided that aren't under the EPSL. I do suggest as well that the FMLA might apply. And again, this is beyond the scope of this conversation, the specific FMLA, again, not the EFMLA, but this is highly dependent on the employer, whether you're covered under the FMLA, and I just use one little example there, and whether the employee meets certain length of service thresholds, requirements, things like that. There may also be coverage under the new Washington Paid Family and Medical Leave. This is a new act that was enacted this year, where there's a employer and employee payment into the system that provides additional paid leave at the Washington state level. And that's also beyond the scope of this presentation, but would certainly be worthy of some analysis if there was a need for additional or different coverage. The second example relates to employees who want time off beginning April 6th to care for her friend who has been quarantined. And this is where I highlight the distinction between a friend who's an individual and a family member, where the FMLA would allow this leave unpaid under the regular FMLA. That FMLA requirement, try that again, the FMLA requirement there is that person be a family member whom you're caring for. Not the case under these new acts, under the Coronavirus Act that we're talking about. First of all, the employer probably has to give the employee time off. And yes, the employee probably gets paid for that time off. Under the EPSL, up to 2 weeks of paid leave must be provided to that employee who's caring for an individual who's been quarantined. That person gets paid 2/3 of their regular pay with the caps that we've already discussed. And the paid time off cannot be deducted from existing accrued leave. But again, the employee has the option of using other accrued time if they have it available. And then the third example, I tried to pull in the EFMLA as well. The school for my employees' children that they go to has been closed through at least April 24th, which is currently the state of Washington and many other states. And the employee has worked for us for 6 months. And then this is important. The very first bullet is that the effective date of the EFMLA and the EPSL is important. There's no coverage under either of these acts, at least for now, until April 2nd. So then before April 2nd, the employee may have coverage, and this is under a state law, that PFML, the Paid Family Medical Leave that I alluded to here at the bottom, the Washington Act that just went into effect in 2020, or the employee may have coverage under the employee's internal sick leave policies. So there would be some opportunity for that employee to get some form of continued pay through some other non-federal act requirement. And then under the EFMLA beginning April 2nd, the employee would qualify for coverage. And again, this is true even though the employee isn't eligible under the FMLA. These provisions kick in as long as that employee has worked for 30 days, and it applies to all employers at this time under 500 employees. The EFMLA applies if the employee is unable to work or telework. Again, keep that in mind. Doesn't mean if they can technically telework and they don't want to, then there may be other leave to use, and they have to have the right to use that if that would be appropriate. If the EFMLA applies, then the first 2 weeks are unpaid under the EFMLA. But this gets to that synthesis between the EFMLA and the EPSL, is that the employee will have other options. Under the EPSL, during the first 2 weeks, that employee can get 2/3 of pay, up to $200 a day or $2,000 total. And then after 2 weeks, the EFMLA kicks in and there's coverage. I think there would be up to, I have to double check myself here. I'm pretty sure it's 12 weeks of coverage here, not 10. So that would be a typo on my part because the 12 weeks is the same as the FMLA. So I'll update on the slides before sending out. And then, of course, the important reminder tip at the bottom there is to keep track of your hours. Tax credits apply, and that can be pretty beneficial down the road. I know in the short term it wouldn't mean much because of the outlay of compensation for employees, but keeping track of the hours will be pretty important. And that's all I got as far as those two acts go. So Colleen, I'm going to stop sharing my screen now and open this up to any dialogue or conversation that anybody's interested in.
Well, so Chris, I see we have 11 questions
Okay.
from folks. Do you see that there? I don't know if you want to start just right at the top.
Okay, yeah, I can start. I can do my best to, do you want me to type answers to these, Colleen, or just answer?
Or I think it's probably best just to, it's best just to read the question and then try to answer it live.
Yeah, okay, fair enough.
If they have a follow-up, they can put it in there, but Linda.
Let's do it. That sounds great.
Too.
The first question from Linda Middleton is, some people have DD or mental health people. I believe DD means developmentally disabled, or mental health people at home that they have to take care of, not kids. And I think that, so I'm going to kind of slide back to the some of the discussion points here to answer that one. I think, so this is the slide that comes to mind in answering the question. I would say that there's not expressly coverage for that under either of these acts, but I believe that there is a strong possibility that this last one here, that the Department of Health and Human Services is empowered to provide implementing regulatory language that would allow perhaps for that coverage. But at this time, I don't believe, unless some other scenario applies to the developmentally disabled at home, that there would be coverage for that. She also, Linda also indicates the question about nonprofits is really important to get relief other than a tax break. And I totally understand that. But at this time, I've studied this stuff like crazy over the last 4 days, and I have not seen anything in reference to that issue. So I can't answer to that, but perhaps somebody else can.
So on Friday, the top two people that are the experts in different divisions, one being shared work and the other is the unemployment compliance and audit division, presenting a webinar at 11 o'clock. They did confirm while we were on this webinar. And so we will be sending that out, and that is definitely a question we will pose to the top person of ESD's compliance and audit division.
Perfect. Thanks, Colleen. And I think I answered the next question, Priscilla Schaefer. The additional 80 hours of sick leave, the employees have to use already accrued sick time first. And the answer, again, is no, they do not, nor can they be required to. Kathy, I jumped in and answered some of these, I think, in real time. Will the EPSL pay to employees who can still work but want to distance themselves from groups, so self-quarantines? And again, I think that catch-all language under the Health and Human Services reference on this page that's on the screen now. I think that's the only place that that question will be answered if it is. Karen asks, is there any documentation required for the benefits? The answer is going to be yes. There is no form that I'm aware of or no specific requirement at this time for how you keep track of the benefits that you're paying out to get the tax credit that you would get for the payment of those benefits. My strong question is that you come up with some form of tracking system that distinguishes employees who are being paid under either of these versus employees using their own sick leave or the state mandated sick leave. And perhaps the implementing regulation will have more detail about what is expected, but at this time, I don't have an answer for that. Jessica asks a great question. What is the federal definition of full-time? And I apologize, I don't actually know the answer to the federal definition there. I suspect it's either 32 or 35 hours a week. But perhaps somebody else has the specific answer. I can look that up on the fly.
You know, Chris, one other thing that has come up, I know that the attorney from the Port of Port Angeles and the attorney from Clallam County don't agree on this interpretation, but it's whether or not the emergency paid sick leave is required to start on April 2nd or whether it started when it was issued.
It would, unless the federal government has the authority to implement sooner than the 15-day window, but all federal regulation is implemented 15 days after the president signs it into law, unless there's a different implementation schedule, and it can be sooner. And that has not come. I looked at that again this morning to see if there's been any update on that, and I did not find anything indicating that there's an intent for this to be implemented sooner than April 2nd.
Okay, thank you.
All right, so I'm going to start checking some of these off so we can make sure we're not. And I think we just answered this question from Bill, the same effective period beginning April 2nd for EPSL. Unless we see something otherwise, the answer is yes. Becky McGinty asks a great question. Since this doesn't go into effect until April 2nd, does this mean employees already laid off are not covered? That's an interesting and complicated question. It depends, well, it would depend on why the employee was laid off. If it was, both of these acts are specific to employee needs, not employer needs. So if an employee was laid off because of a slowdown or a need to shut the business down because of the shelter in place or whatever, there wouldn't be any coverage for that under either of these acts, as far as I can tell. And that then dovetails into the stuff Colleen was alluding to earlier with the new CARES Act. That is the similar, where there would be potentially a plethora of benefits to small businesses and other employers under that act for the circumstances that have required an economic slowdown of your business or shutting it down altogether, but not under these. Bill asked a question. Any thoughts on how this does not pencil out for employers? Wages paid will far exceed credit for payroll taxes due. And I think that is one of the first things I thought about as I started to learn more about this act, is that I don't think that it was passed really with an eye on the best interest of the employer at all. And you probably experienced that with other acts that are passed at the federal or state level as well. This one, and this is only my personal opinion, but this is, I think, passed in a very fast, aggressive timeline to address the very dire and acute conditions that employees are facing, both with respect to being infected, possibly infected, people you know and love for being affected, and then your kids being affected with the school closures. As well as a quick answer for those circumstances only, and with, I think, an attempt to waylay the employer concerns as best as the act could by offering a payroll tax credit. And I think that's kind of the analysis that would be appropriate.
So Chris, if I can add, I believe that's why the CARES Act, the SBA loan 7A Paycheck Protection Program that has not yet been voted on by the House, but is expected today. And then the president has said he would sign it. Allow for funding for these businesses that have this upfront expense that they can't in many times afford, but they get the loan, they don't have to make any payments for 1 year. And if you've kept your employees on and you have them employed through June 30th, then you do not have to pay that portion back that went to the payroll. So that's how they're planning on covering it. But that being said, you know, it will take a while for your company to get that money.
Mm-hmm. Yep. And that lag time is going to be really challenging for an unimaginable number of businesses locally and nationally that are affected by this. And keep in mind, as we're talking about this, that there is, I believe, very likely to be an exemption for those with employees of less than 25 people. Again, the labor and how to implement that regulation, and has not indicated how that's going to work or if they're going to do that. But I suspect there's a strong sense of equity or fairness that small employee, or really small employees, try that again, small employers can't swing this. It's just too much. So we'll see how that plays out. Jeff asks, are all of these applicable to union employees as well? I would say as long as those union employees are hourly, then absolutely. And it would be in addition to whatever benefits are provided through the collective bargaining agreement as well. So it would be, again, collateral coverage, not first or preferred. Michael asks a good question. Under the EPSL Act, a part-time employee, are they expected, they work 20 hours a week, do they still get the 80 hours, or are they limited to 40? My interpretation is they are entitled to get what they would normally get. So if they work 20 hours a week and they've worked for more than 6 months, so you can document that on average, then 20 hours a week is what they would be covered for under the EPSL. Can we require proof of doctor's orders to stay home? I would say unequivocally no, that you cannot require any doctor's orders or note for this coverage. I wouldn't recommend that. I think if somebody is symptomatic and because of the inundation with the healthcare system that is being seen right now across the country, getting a doctor's attention at all, I think for a younger person who may be infected is going to be really challenging. And there's a lot of stories out there about that. So I don't think this would be a good idea. Mike Skinner asked about practice tips for best ways to track hours. This is a hard one because with the federal government, I expect there to be some kind of onerous form that has to be filled out for this. But as of now, there is no instruction or any helpful information from the federal government to help with this. That's part of the implementing regulation that is expected imminently. Does this act apply to those in healthcare positions, such as, so I don't know the specific answer on the distinction between these different types of healthcare professionals, but for example, under the EFMLA, there's a specific exemption for healthcare workers. So there, the intent is for health workers to be at work. And so what the federal government, I believe, is trying to do is dissuade them from trying to use this kind of coverage to stay home and to come up with other options for care for their kids. Under the EPSL, I did not see anything specific to healthcare workers that would exempt them or suggest that they do or do not qualify. Obviously, if a healthcare worker is symptomatic, I would say there's unquestionably coverage under the EPSL. But when we get into questions about coverage for care for kids, that's the part of that 2/3 coverage that's it's on this page here. I'm not totally clear on whether there would be coverage or not. Because I haven't seen anything suggesting there isn't, my answer, at least off the cuff, would be that there is under the EPSL, but not under the EFMLA, but that would be subject to change. Does the employee need anything? Is a question from Karen. And I don't know exactly how to answer that question. I think it just depends on the circumstance. If they're symptomatic, the employee needs to speak up and stay home and then communicate by phone with their employer. The employee under the EPSL is required to be notified by the employer of the coverage that's there so that the employee would know that they have the right to use that coverage. And so I think that the employee would need that from the employer, but beyond that, I don't believe that they need any additional proof. And as an employer, I would not require anything but beyond reasonable proof that would get you to a place where you can make the determination that they qualify. Susie asks a great question as well. For folks who've already received notes from their doctors to self-isolate, but they are not symptomatic, do they have to wait till April 2nd for these benefits to take effect? The answer is yes. They're not retroactive before April 2nd unless the federal government dictates otherwise in implementing legislation, and I haven't seen that. And at this point, I don't think that is likely. That would be this is already onerous enough, and I think creating retroactivity beyond expectation or before April 2nd could create additional problems. So I don't suspect that they will do that, but I obviously don't know the answer to that. But there would be no coverage under either of these acts for anything before April 2nd. And I think I answered Lizzie's question as well. It's the same question. Brad asks a really good question, and this is affectionately referred to as the gig economy, where there's a lot of self-employed people that work from home or otherwise. Can you address self-employed household potential funding for those of us who have to stay at home? For example, a general contractor in construction and otherwise. I don't think that there's any coverage in this instance under either of these acts, but the CARES Act that Colleen has mentioned has very specific coverage for the self-employed gig economy worker. And so there will be an awful lot coming out about that. I don't have the specifics in front of me, but as I was reviewing the various tenets of that act, there's a pretty big chunk of change set aside to address specific claims by self-employed people. Mark, Hannah asks a great question as well. Will there be a list of people who can help? I don't know the answer to that. I mean, you have a list of one. I'm happy to help however I can. Hopefully, there are good resources being compiled locally, regionally, on a state level, and nationally to really help answer these questions.
I guess that's Mark. I was going to say, we have a group of people that are being trained on this, and Mark Hanna is one of them, our SCORE counselor. But also Mike Rykoff is being trained with the SBC, the Center for Inclusive Entrepreneurship, and NODC. We're all working together and we're all learning about this together. And so obviously Chris is a really important resource for us, and really appreciate that.
Thanks, Colleen. Jack asks a really good question, and it's what about exempt salaried employees? And I don't believe there is coverage under the EPSL for exempt salaried employees. I'm not sure under the EFMLA, but I don't think so. I think it would be the same requirement that they be on under both acts, and because I believe that's also true for the FMLA. but I may be speaking out of turn there because I haven't looked specifically at that question, Jack. So, not being able to answer it. And I see that's the last typed question. I'm checking my comments. I'm also multitasking and trying to find the answer to that question. Are there any other questions?
No, but it is 2 o'clock, so I've got to jump off. And I will be sending out the invitation for Raphael and Sile Christmas, who are both from ESD, the UI compliance and lead on emergency rulings. So be sure to tune into that on Friday at 11 o'clock. We will send out the link, and thank you to Brandino Gibson at the Employment Security Department WorkSource office for setting that up for us. Thank you. I'm going to sign off now, but continue to ask questions and answer.
Okay. Thanks, Colleen. There's a few more questions that popped up. Priscilla asks, can you advise when there will be information regarding exemption for companies under 50 employees? And the best I can tell you at this time is it would make an awful lot of sense for that to come out before April 2nd. We're a week after this act was passed and there still isn't any. That's actually surprising to me. But I can't imagine how inundated these regulatory bodies are already with other things, and trying to also come up with implementing legislation can be remarkably challenging. But at this time, I have no idea. Jim asks what the penalties are for not being able to pay the employees. And it depends on who's applying the penalty. There is a private right of action in some instances where an employee could sue the employer for, under the EPSL, it would be under a Wage Payment Act claim. So it would be subject to similar standards there, being able to collect fees and costs and then up to double damages. There are other regulatory oriented penalties for not paying employees that I can't speak specifically to, Jim, at this time because I'm not aware of them, but I know that both acts allude to either a private right of action or a potential penalty for failure to comply. If you're interested, Jim, in more specific information, I could probably hunt that down and hopefully be able to provide better information, but that's the best I can do for now. And that's it. That's all I see. Oh, Priscilla's clarifying. Would you let us know when that implementing legislation is out? I can do that through Colleen, certainly. And so when I find out and have time to study that, I can do my best either to resource you to other places on the web that can probably answer specific questions, or kick out another either just a simple memo or something that provides more information. I'd be happy to do that. Okay, well, I am going to sign off. I appreciate everybody's time and listening. I hope it was helpful information. Colleen will send this out, and again, my email address is on the second or third slide of this thing, so you can feel free to get in touch with me, and I'll do my best to provide answers or be a resource for you that I can under these circumstances, and understanding there might be a little lag from me in my ability to get back to you because at First Federal things are really busy as well, and us trying to figure out how to best manage this as a bank. So again, I appreciate everybody's time. Thanks for listening, and I will hopefully see you around. Thank you.